For months, we've tracked the back and forth between Valve and the New York Attorney General. We covered the Steam support announcements, the doubling down with marketplace updates, and the disappointment Valve expressed when the lawsuit was first filed. But that was just the beginning. On May 18th, 2026, Valve filed a 42-page motion to dismiss in the New York Supreme Court. It's an explicit, aggressive, and highly detailed legal argument that effectively accuses the New York Attorney General of misunderstanding the law, overstepping their constitutional authority, and threatening to criminalize everyday American life. If you own items in Counter-Strike 2, Dota 2, Team Fortress 2, or just use Steam in general, this document is very important. Today we are going inside the filing. We're going to look at the specific quotes, Valve's defense, and why Valve thinks the New York Attorney General is trying to make up laws that don't exist. This is the legal showdown we've been waiting for. The core of the New York Attorney General's argument has always been simple. They believe these mystery boxes are slot machines. They argue that Valve lures users to gamble for virtual prizes, and because those prizes have value, sometimes thousands of dollars, it meets the legal definition of gambling. Valve's lawyers have now dismantled this claim with surgical precision. They point to New York Penal Law, Section 225.00, which defines gambling as a person who stakes or risks something of value upon the outcome of a contest of chance. Valve's argument: there is no stake and no risk. In the filing, they explicitly state, because every player always receives exactly what he paid for, one skin per mystery box, there is no stake or risk. Just think about that. In a casino, you put money in and you might get nothing back. In a Counter-Strike case, you pay the flat fee and you get a digital item. It might not be the rare item you wanted, but you didn't leave empty-handed. Valve argues that the gamble isn't a gamble because the exchange is guaranteed. This leads to their most viral argument, the baseball card defense. They point out that the New York Attorney General's interpretation would categorize a breathtaking amount of commonplace conduct as illegal. Valve uses this to lay out a slippery slope for the judge. If the court accepts the New York Attorney General's definition of gambling, you can't just stop at Counter-Strike. You would logically have to go after baseball cards, Pokemon packs, Happy Meals, cereal boxes, Labubus, fashion subscriptions, and even arcade establishments like Chuck E. Cheese. This is a brilliant strategic move. They are shifting the debate from Valve versus the state to the state versus common sense. This is where Valve accuses the New York Attorney General of trying to rewrite the law from the Attorney General's office. Valve argues that the New York Constitution's prohibition against gambling is not self-executing. That means the Constitution alone isn't enough to just shut down a business. You need specific, modern legislation passed by the actual state legislator. Valve points out a crucial fact. The New York legislator has already considered bills that would regulate loot boxes, and they haven't passed them. Valve's lawyers essentially argue, you are the Attorney General, you are meant to enforce the law, not invent it. The filing mentions no court has allowed the executive branch to criminalize overnight such a breathtaking amount of commonplace conduct not specifically prescribed by a statute. This court should not be the first. They are telling the judge that if the government wanted to ban loot boxes, it was the legislator's job to do it, not the New York Attorney General. This is a separation of power argument, and it's the strongest weapon in Valve's arsenal. It places the New York Attorney General in a position where they appear to be overreaching their constitutional mandate to score political points against the tech industry. But Valve isn't just arguing about the law, as they are also making a massive constitutional stand. Their filing claims that the New York Attorney General's entire approach is a direct violation of the First Amendment. Valve's lawyers are making a point that developers everywhere are watching. You cannot simply redefine creative game design as illegal conduct. In the motion, Valve explicitly states the First Amendment is not so feeble that it can be circumvented by framing acts of creation as conduct rather than expression. They argue that skins themselves are purely aesthetic creations and are fully protected by the First Amendment. By trying to criminalize the mystery boxes that contain these skins, Valve argues that the New York Attorney General is effectively chilling creative expression. Valve warns the court that if developers have to live in fear of their own game mechanics being redefined as illegal, they will simply stop innovating. Their filing says, when developers must guess what features are illegal, they necessarily will steer far wider of the unlawful zone. Valve argues the state's case is fatally under and over-inclusive. Valve is telling the court that this is about protecting the right of developers to build complex, engaging worlds without a local regulator redefining their mechanics as criminal whenever it fits a political narrative. Another key pillar of the New York Attorney General's case is that Valve is knowingly violating gambling laws, but Valve is leaning into its over-decade-long history of operating in the open to refute this. They point out that they have been operating these mystery boxes for over 10 years. They have paid New York state taxes on these purchases, and most importantly, no other state or federal regulator has ever successfully classified this as illegal gambling. Valve writes, Valve has openly offered mystery boxes and paid New York state taxes on those purchases for more than a decade without objection from New York Attorney General or any other regulator. So how can it be a knowing violation of a criminal statute, they argue, if the state has been taking tax money from those transactions for years without a peep? Valve is claiming they had no fair notice that their business model, which has been taxed by the state for a decade, was suddenly a criminal enterprise. It's a very difficult argument for the New York Attorney General to counter without making their state look incompetent. Finally, we have to talk about the money. The New York Attorney General has focused heavily on the fact that some skins sell for thousands of dollars or even over $1 million. They use this to argue that the items are money. Valve retorts that this is a massive misunderstanding of what a skin is. They characterize these items as having subjective and aesthetic value. They argue that the marketplace prices are driven by player desirability, not intrinsic monetary value. Owning a skin worth thousands of dollars isn't going to make you perform better than someone with none. The New York Attorney General has focused heavily on the argument that skins are money or property because they can be sold for real-world cash on third-party websites or converted via workarounds. Valve lawyers argue that the New York Attorney General simply doesn't understand the law. They point out that under New York penal law, tokens and objects are legally defined as physical items. In the filing, Valve states skins then plainly are not tokens, objects, or articles because they are digital, not physical. But what about the third-party websites where people do sell skins for cash? The New York Attorney General argues this makes skins exchangeable for money. Valve shuts this down immediately, noting that just because an item can be resold by a third party doesn't make the item itself money. As they argue in the motion, if exchangeable for money or property encompassed any item that can theoretically be resold, the definition would have no meaning or limiting principle. Valve also makes a critical point about their own rules. They remind the court that their subscriber agreement expressly prohibits the exchange of skins outside of Steam. They argue Valve, like any other private video game developer, bears responsibility only for its own actions. New York Attorney General cannot seriously suggest that Valve should be held criminally liable for third-party websites because it failed to shut them down, which it cannot do, or failed to enforce the SSA terms outside of Steam. Finally, Valve addresses the Steam wallet argument. The New York Attorney General tries to claim that because you can trade skins for Steam wallet funds, Valve counters that Steam wallet funds are not property as a matter of law. They quote their own terms, noting that Steam wallet funds have no cash value and are not exchangeable for cash. By framing it this way, Valve is positioning the New York Attorney General's entire argument as a misunderstanding of both technology and the law. So you might be wondering, is this a win for Valve? And we have to be realistic. This is just a motion to dismiss. It doesn't mean the case is over tomorrow, but it does mean the New York Attorney General is now under immense pressure to prove that their interpretation of the law isn't nonsensical. Valve's lawyers have laid a trap. If the judge agrees with the New York Attorney General, they aren't just hurting Valve and their cases. They are setting a precedent that could affect every hobby store, every arcade, and every card game manufacturer in New York. Make sure you subscribe to stay updated on everything you want to know about this case.